So we can actually see this is on High Court of Australia for case number S160/2024, Farmer v. Minister for Home Affairs, and of course the Commonwealth of Australia. And you guys can see here's some case information. Um, and they're giving some catchwords here: constitutional law, Migration Act. This is stuff that's cited in the court documents, okay? Where the plaintiff is a citizen of the U.S. and not a citizen or resident of Australia. Plaintiff is an internationally recognized political commentator, meaning she's a public figure. Candace, you got to stop acting as if you don't understand the concept of a public figure. Because when these defamation cases keep coming upon you hard and heavy, then it's not going to be difficult for people to prove malice intent when you keep throwing their names out there and then saying that they had something to do with someone's death. You understand what you're saying when you say those things? Or maybe not. Then you'll learn the hard way. I don't know, whatever. All right. Plaintiff applied for a temporary activity class GG visa for her proposed travel to Australia, where the Minister for Home Affairs decided to refuse to grant the plaintiff the visa, relying on S as in Sam 501 6 D as in dog IV, which is 4, Roman numeral 4, of the Act in making the decision, where the minister reasonably suspects the plaintiff does not pass the character test, and that is in the national interest to refuse to grant the plaintiff a visa. Validity, and then of course they cite the statute again, where invalid on the ground that it infringes upon the implied freedom of political communication, which is what her and her attorneys are, alleging here. They're saying that, it infringes upon the implied freedom of political commutation to sit here to say you're going to deny her visa. She hasn't even came there yet and said anything, even though she's been saying all the things she's been saying in videos. And whether the minister adopted an incorrect construction of this statute here. All right. So now that you guys got the summary, let's go down to some of the documents. There's an order here on March 13th. Yeah! What does this say? Here is one of the orders. Oh, crap. Y'all, Lady Luck Club, we're awesome here. High Court of Australia notice of filing. This document was filed electronically in the High Court of Australia, March 13th, 2025. So that was the order I wanted to see. And has been accepted for filing under the High Court Rules 2004. All right, so we got the details of filing here. You can see the file number, and you see the title, registry in Sydney. Okay, so what does it say? Come on, let's get to it. Okay, here we go. Here's an order. Look at that. So you got Candace Owens Farmer versus the Minister for Home Affairs and Commonwealth of Australia. Justice Jagged, Jagot. I hope I know. I don't know if I want to mess that up. Special case consent. Okay. By consent, the court orders that, pursuant to R27.08.1 of the High Court Rules 2004, the questions of law stated by the parties in the special case be referred for the opinion of the full court. Okay, unless otherwise ordered or directed, Part 44 of the High Court Rules 2004 relating to written and oral submissions apply with any necessary adaptation to this proceeding. On or before March 18, 25, plaintiff filed and served a special case book in accordance with an index settled by the registrar. March 20th, the plaintiff filed and served the plaintiff's submission. So they're basically saying what, she filed into the case in chronology to deal with the questions of law stated in the special case. March 27th, any intervener in support of the plaintiff filed and served submissions to deal with the questions of law. April 10, defendant filed and served defendant submissions to deal with the questions of law. April 16th, this is this year, you all. Any interveners in support of the defendants or not in support of any party filed and served submissions. April 22nd, plaintiff filed and served any submissions in reply to that. So she filed some documents. The defendants filed their documents in response to that, and then she got to file a reply. And then, of course, April 23rd, the plaintiff filed and served the Joint Book of Authorities. And this was signed March 13th, 25, and you see the seal and signature there. All right, so let's see what happened with that. And this is the order you all just read here. All right, so we can go from top down to the bottom. Boom shakalaka, boom shakalaka. There you go. So I just want you all to see this. We got the order that came on March 13th. This order here, as you guys can see, here's the case number and everything, is basically referring this case to the high court. Special case consent. So they referred it to the high court for them to make a determination on this. This is all over her getting a visa to go to someone else's country. The end. It's just all it is for her to go to another country. All right, so let's see here. Y'all, they have the on June 5th. Okay, so here's June 5th, but May 6th. I'm sorry. May 6th. I forget. Date, month, year. May 6th. May 6th. They have the hearing. They also have the video. So if you were to go on the website here, which will be in the description of the video, you will be able to click on the hearing here to take you out to the transcript, I think. And this here will take you to the actual video hearing. It was recorded. So you have an outline of oral argument by the plaintiff that was filed May 6th. Let's take a look at this. Y'all, we got court docs for days. Oh my God. Look at this. So this is basically her saying their outline for oral argument, which is what you will hear and see in that video, except this is more of a summary. Okay. So they speak on the certification, and then they speak on the meaning of Section 5016D4 of the Migration Act. They give a breakdown on that. The section means that a person does not pass the character test if, let me just zoom in so you all can see this. This section means that a person does not pass the character test if, in the event the person were allowed to enter or remain in Australia, there is a risk that the person would cause disagreement or debate in the Australian community or in a segment of that community. There is no clear line between disagreement and debate on one hand and dissension or strife on the other. This is the plaintiff's outline for oral argument, okay? So this is Candace's attorneys making this argument. And then we're going to read the defendants. It is necessary to give Statute 501 work to do. Only Statute 501 incorporates a danger requirement. The use of the word incite does not support the defendant's construction. The legislative history indicates a deliberately broad meaning. So they're basically saying, you know, you guys are talking about she's a danger. You're not really defining, what kind of division or incite, what does incite mean in this situation? To say that there's a disagreement or debate is not necessarily a justification to say she can't get a visa. That's pretty much their argument. And then they cite other cases. There's a memorandum, kind of like an amendment or an act here in the U.S. And then they state here the fact that statute 5016D 1 through 3 deal with apparently quite serious harms does not support the defendant's construction. Then they speak on the constitutional validity of that law. So they're trying to invalidate it. They're trying to say it doesn't really have any merit in this matter. It doesn't apply in this particular situation because she hasn't came there yet. She ain't said nothing. And never mind all the stuff she has said, it doesn't mean it's going to cause any strife or discord in Australia. But I mean, when has it not caused strife or discord? You can't make this stuff up. The validity of the minister's decision. Okay, so the minister had decided to not give her a visa, right? This is what they're appealing. They're appealing that decision where he said, nope, you can't get it. Don't care. Go throw a tantrum about it, go cry somewhere else. So under the assumption the defendant's construction is correct, the minister misconstrued the statute in two ways. right? The minister did not construe discord as needing to be in the nature of strife, dispute, disharmony, or dissension. The minister did not construe discord as containing a requirement of the causation of harm to the Australian community or a segment thereof, such that the persons represent a danger to that community. They didn't really get into detail, according to the plaintiff, as to how she's going to somehow bring about strife or discord or dissension or some sort of debate or harmony or danger. How does she disrupt the harmony? How does that happen? I mean, all they have to do is play all her videos. All right, and then relief they're seeking, in addition to the other relief sought by the plaintiff, the court should issue a writ of perambulatory mandamus if Statute 501 is invalid. So if it's invalid, then the court should issue a writ of perambulatory mandamus. All right, so let's go to see what the outline of the argument was from the defendant. So we're going to scroll down here. You guys see here the case information, Form 27F, defendant's outline or argument. And this was on May 6th. This was filed on May 6th. The hearings, I think, was May 5th. And you guys can see the case information there. So they start with propositions to be advanced in the oral argument, proper construction of incite discord. So they're basically saying a risk that a person would incite discord does not refer merely to causing disagreement or debate. It refers to the risk that the person would stir up strife or dissension in the Australian community or a segment of it of a kind that involves harm to that community or segment. So they're saying, we're not just saying that she's going to create some sort of disagreement here. No. She's going to create the type of disagreement that can become dangerous. So when she's out attacking Jewish people, she's putting Jewish people's lives in danger because of her rhetoric. That's what they mean. And then they're saying all her videos is sitting here attacking people by their ethnicity or by their religion, and she doesn't care about the backlash of it because Candace Owens can't control her base. And there are some crazy people that support her. And she can't say that these people aren't going to go out and do harmful, dangerous things in her name. Just like when she was sitting here talking about Phil Lyman, where's his mother, who's the nephew, cousin, and then that man had to delete all his social media because people were harassing him online. He didn't have a moment's peace. So it's not exactly her telling people to go and do things. It's the fact that the things that she says incites people to want to do dangerous things to whomever she's targeting. And that's absolutely correct, because I have been speaking on the dangers of Candace Owens' accusations trying to connect innocent people to Charlie Kirk's death, and her base is incited by going out and looking for these people, researching all these people like Phil Lyman and his family, simply because she put their name out there and said, I find it very suspicious and odd that he would want to retrace the steps of the killer. Why does he have so much interest in this? Like no one else can be interested in what happened to Charlie Kirk. Candace, you are not his only friend. You weren't even the only woman in his life. He had a whole wife. But this is what she does in every situation. So it's not just this case where that could be easily proven, but they could use the other examples of how she induces this cyber harassment online, because she's just putting out people's names. Josh Hammer is thinking about filing something against her. I mean, to the point where people want to file defamation lawsuits. Brigitte Macron, the First Lady of France, she's tied up in litigation matters that prove the point that they're trying to make in Australia. You incite people to do dangerous things. Your words could be defamatory. It could cause great harm and danger to our community, especially a particular segment of that community, i.e., the Jewish community. Now, do you all see how this goes? Sometimes it just takes a little breaking down and understanding, and then being able to correlate other examples into the equation. So, of course, they speak to context. They give more case law. They give some sort of history. The Lim 5 has its origin in para C of the public interest criteria previously found in the migration regulations. The paragraph was interpreted by that paragraph was interpreted by the federal court to include the conduct now addressed in limbs is like sections 3 through 4, and not to extend to mere disagreement or debate. And then they cite case law here. Y'all decide they cite their case law. All right, so that's a case. That's a case. Here's another case. And you're welcome. Then they give other sections of that statute 5016 to kind of support it. So they're saying it's not deliberately broader than the paragraphs in this section here. It basically comes down to this. You represent a danger to the Australian community based on other factors that are being met in that same statute. And then there are case law to support how that same law was interpreted in other cases. The implied freedom of political communication. There's a burden for that. Statute 5016D4 does not burden the implied freedom for two reasons. It does not burden any right or liberty arising independently of the act. Without a visa, an alien, because you see he's an alien there. Candace, you're an alien in Australia, okay? You don't have to be over there. God, that's funny. First, it does not burden any right or liberty arising independently of the act. Without a visa, an alien has no right or liberty to enter Australia. Is that enough said? Without a visa, an alien from outer space has no right or liberty to enter Australia. Candace, you don't have the right or liberty to enter Australia without that visa. Okay? They don't have to let you over there. Even if you ask nicely, how do you make up for all the harmful things you've said about particular sections of a community? Like the Jewish community. You keep harping on them. Section 501 is one of the provisions of the Migration Act, which define when an alien will be granted a visa to enter Australia. Okay? The plaintiff's attempt to establish a burden by asserting that she has a right to a visa, but for Statute 5016D4 is foreclosed by unchallenged authority. So her attempt in saying I have the right to get a visa there because reasons does not fit under this statute. You can say whatever you want, but just like with the Macrons, Lady Macron does not have to give you any blood, Candace. You're the one accusing her of being born a man. Why does she owe you DNA to prove your point? Her burden will be to prove that she is a woman and that you lied. The end. They don't owe you anything for that. They've given her exhibits and documents, and she just doesn't want to accept it. The court will not care about that, Candace. Just like here, you're trying to establish a burden by asserting that you have the right to a visa. That's not what this statute speaks to. It doesn't say anything about you having, just because you believe you have the right to get a visa to go to Australia, does not mean that your political communication is being, somehow challenged or restricted. No one's silencing your free speech because you think that you have the right to get a visa there. And they said no. Bye, girl. Bye, Felicia. Bye, Felicia. Section 5016D4 does not burden the liberty of Australian citizens and residents to engage in political communications with each other or with aliens who are in Australia or who are located overseas. They keep calling you an alien, Candace, because they want you to know that you're an alien. Because you don't live there and you don't belong there. You see how that feels? Doesn't feel good when there's another country calling you an alien, does it? You know, it does not burden the liberty of Australian citizens and residents to engage in that political communication with each other or with aliens who are in Australia or who are located overseas. The implied freedom, being a restriction on legislative power, confers no right upon any person to require an alien to be granted permission to enter Australia to engage in political discussions here. So, in other words, this implied freedom you have here, okay? Everybody has the right to say what they want to say. It doesn't confer any right upon someone to be granted a visa or any permission to enter Australia to engage in those political discussions. You can say what you want to say, but it doesn't mean we have to give you a visa to come to our country. Those are two different things. You're trying to say they're not giving me a visa, therefore they're infringing upon my freedom of political commentation. No, they're not. They're saying you can say what the hell you want to say, but it doesn't mean that you should be automatically granted the right to come to Australia. Those are two separate matters. So no one is restricting upon your implied freedom, to have political discussions here. But it doesn't mean that you don't have the right to be granted permission to enter Australia. You can't make this up. Well said. Secondly, this statute, Section 501(6)(d)(4) is a definitional provision. Even when read with a statute 501(3)(a), it imposes no burden unless the discretion is exercised to refuse an alien permission to enter Australia. Oh, man. It imposes no burden unless the discretion is exercised to refuse an alien permission to enter Australia. There's no burden that's imposed based on that section. It basically just kind of defines what that provision is. It defines that statute. All right. It has nothing to do with, imposing some burden unless it is specifically dealing with, and you're talking about them having the discretion to grant you a visa. So that's what they're saying here. The refusal of an alien to come to our country, it has nothing to do with how this provision is to be defined. We're simply saying here, you can't imply that your right to do anything is being restricted or that there's some undue burden. Because we're telling you, based on this statute here, we have the discretion that we can exercise to not grant you a visa. You're an alien and you don't have to come to our country. If that provision is not valid in all its operations, it must be read down or partially disapplied so as to permit only those exercises of discretion that are within constitutional limits. And then they have case law here. Alternatively, any burden arising from Statute 501(6)(d)(4) is slight. At most, it imposes some limits on the manner in which a small subset of political communication can occur. Justification: if the defendant's construction of a Statute 501(6)(d)(4) is adopted, it is readily seen to be reasonably appropriate and adapted to the legitimate purpose identified. And then they have DS42, the plaintiff's submission that an obvious and compelling alternative to this statute is reverting to the initial risk threshold cannot be accepted because a provision in that form would not achieve Parliament's purpose to the same or a similar extent. Further, the provision is adequate in its balance, for any burden is so slight that it cannot manifestly outweigh its legitimate purpose. So the burden that you're implying here does not outweigh the overall purpose of what that statute serves. The end. Let's see here. I want to make sure I just get down to the bottom. The minister did not misconstrue the statute. The minister did not use the term incite discord to refer merely to disagreement or debate. He found there to be a risk that the plaintiff's expression of her views in Australia would amplify grievances among communities and lead to increased hostility and violent or radical action because Candace cannot control her base. Where is he lying? Candace cannot control her base. So he's not lying in this. He's telling the truth. So this is where we are, people. So the grievances that, let's say, the Jewish community would have in Australia would be amplified because they fear that based on the things that she said already and the things that she would say in Australia would lead to increased hostility and violent or radical action. Because she already has 5 million plus people on her YouTube channel that are supporting her every word she says. They don't even question. So we can't say the communities that are already reaching out to us saying we don't want her here because we don't need that nonsense. You can't say that that would not be amplified if she were to come here and then buckle down and double down on the things that she's saying, especially when she's targeting certain communities. And the people listening to her, how do you know they won't go out and do violent stuff? They've already been incited to, do cyber harassment and cyber stalking, cyber bullying. These people fear for their lives. They believe that if she comes here and she incites them even more in person now, they're going to go to those communities and do some nonsense that would incur violence and hostility and radical action. And we can't have that. That is the risk of discord that was found to engage Statute 501-64. Nor did the minister equate discord and harm. So, peremptory mandamus should not issue if Statute 501-64 is invalid. If it's invalid, the minister is under an enforceable duty to make a decision under Statute 65, but there is no basis upon which the court should order the minister to grant a visa. The material before the court does not establish the plaintiff either passes the other limbs of the character test or satisfies PIC 4001 and indeed suggests otherwise. Neither plaintiff, and they cite case law here, nor the matters relied in PS 66 provide any support for such relief. So basically, there's no basis to which this court should be ordering the minister to grant a visa to her. Not under this statute. There's no what legal basis can you give to say based on this particular statute that he used to say I'm not granting it, where in that same statute should the court order him, the minister, to grant her a visa? That is the legal argument here. So y'all, this is something else. And let's go back to this tab here, and as you all can see, October 15, 2025, judgment summary will be provided. So today is October 11, 2025. So in 4 days, so that's Tuesday. Is that Tuesday? Yep. Today is the 11th, tomorrow's the 12th. No, that's Wednesday. 13th is Monday, 14th Tuesday, 15th. October 15th, we should see an update from the High Court of Australia regarding some judgment or judgment summary, and we will be looking out for that, as well as doing an update on her lawsuit against that the Macrons have filed against her. So we're looking out for this stuff, y'all. And I have another case I want to go over when it comes to Candace Owens because she's a hypocrite and all. And she acts as if she doesn't know how court works, but yet, Candace, you're filing all of these appeals to the highest court in Australia, and for what? They're not obligated to give you a visa. And you're going to have to give back refunds because no one should be paying $1,500 to have a dinner with you. That's absolutely absurd. Now, if people want to be dumb enough to pay that type of money, whatever. But you could be buying anything else. Why don't you just donate to the Lady Luck Club because you want to. But should you choose to not financially support, hitting that like button is free. Subscribing is free to do. Commenting in the comment section is free to do. So I encourage you all to do all 3 of those things. Hit the like button, subscribe, and let me know your thoughts in the comment section. Let me know what you think the judgment summary is going to be on Wednesday, October 15th, in the year of our Lord 2025. Thank you all so much for listening in. Make sure you check the description of the video for the links for all of the documents that I have presented today in this video, plus the Dr. Squash products that are tagged. We have a partnership with him here in the Lady Luck Club. And yes, I do receive a commission on the sales. So go buy some Dr. Squash soap, deodorant, toiletries for your loved ones. Christmas will be soon around the corner, so you can just buy some Dr. Squash soap products and just put it in the stockings for the stocking stuffers. Yeah. And make sure you give a shout out. All right. Thank you so much for tuning in. I appreciate all of you here in the LLC and all of your support. And until the next one, Lady Luck Club out. Deuces.